Good evening, and thanks for coming out tonight. Some of us have been in this room for quite some time today. You know, there was an election in the United States, and we've been following various election returns today. So for my students, it's been a long day sitting in the same room. But depending on your political persuasion, it was either a very happy day or a very sad day. I'm happy, but I don't know that everyone necessarily is. What I would like to do is take us from 2012 back to the spring of 1946. And I want to open with just two brief stories to kind of get you into what I want to talk about tonight. And in the spring of 1946, two people by the name of Orsil and Minnie McGee turned to the Detroit branch of the National Association for the Advancement of Colored Peoples, the NAACP, and they were looking for some help. There was a group of white property owners in northwestern Detroit who had gone to court in Wayne County to essentially oust the McGees, who were African American, from their home, the home that they had purchased some 10 years earlier. The case rested on what was called a racially restrictive covenant. It was one adopted by white homeowners that said that no property in the neighborhood could, quote, be used or occupied by any persons other than those of the Caucasian race. Among those who signed the covenant were the white couple who had sold their home to the McGees some 10 years ago. So two Detroit-based African-American attorneys, they were both members of the NAACP's National Legal Committee, decided to take the case. And the initial court ruled against the McGees. So their attorneys decided that they would appeal this to the Supreme Court of Michigan. And in writing the brief that they submitted to the court, they emphasized the ways in which this lower court ruling was contrary to what they termed sound public policy. And to support that argument, the brief gave sustained attention to the decision of a neighboring court, not an American court, but a Canadian court in Ontario. Ontario is the Canadian province that's right next to Michigan. And it was a decision in Canadian court terms known as In Re Drummond Wren. And it was a decision that refused to enforce a similar restrictive covenant in Canada. This was a restrictive covenant against Jews. And the case, or the decision, argued that the reason that that could not be enforced was that it violated the human rights provisions of the United Nations Charter, which Canada had just ratified. The relevance of the opinion in the Wren case, the brief in Michigan continued, was reinforced, quote, by the wide official acceptance of the international policies and declarations frowning on the type of discrimination which the covenant would seem to perpetuate. So, at the same moment that this is happening in Detroit, in California, Kajiro Oyama challenged the state of California's appropriation of property that he had bought for his son. Oyama was a Japanese national who had lived in the United States for more than 30 years, but because of federal naturalization law at that point was ineligible for American citizenship. In fact, he had bought this property in the 1930s. He had bought it under his son's name. His son was 6 when he bought the property, but his son was an American citizen. So, at issue in this case was something called the California Alien Land Law that essentially prohibited resident aliens from owning agricultural land in the state. But its real effect was to be targeted at persons of Japanese descent. It was always possible for resident aliens to arrange for gifts of land to their citizen children, in theory at least, but the state of California made it as difficult as possible to do so in practice. Now, as it happened, the state had changed the reporting requirements during World War II for land that had been registered in this way, and Oyama had failed to comply with this new measure, largely because he and his family had been detained in concentration camps for Japanese Americans that were established during the war. So, in this case, Oyama versus California, Oyama's lawyers argue before the California Supreme Court that the alien land law was, quote, a discriminatory law denying Japanese aliens solely because of their race, the rights guaranteed to all others, aliens and citizens. And to support this claim, they argued that California law, quote, flaunts for all the world to see a conflict with the Charter of the United Nations. These two cases, Sipes versus McGee and Oyama versus California, were the first of an escalating series of cases that made their way through American courts in the 1940s, all of which employed what then was a novel legal argument that the controlling authority of international human rights norms trumped existing federal or state law. Most often, they pointed to the language of the United Nations Charter itself and its promises of protections for individual human rights across national borders. These cases were brought by Japanese Americans, they were brought by African Americans, they were brought by Native Americans, and they all used a transnational frame to approach a variety of instances of domestic discrimination. In some cases in housing, in other cases in land and fishing rights, in cases of public accommodation, in education, and also in one case where a dead body could come to rest. Together, they mark the first instance after 1945 of global human rights norms entering directly into American political and juridical processes. Now, my interest in these cases is part of a larger book that I'm working on that seeks to examine how the United States both shaped and was shaped by the emergence of what I call a global human rights imagination after 1945. With few exceptions, post-war human rights have largely been written out of United States history, at least until the 1970s. Instead, at least in US foreign policy history, the Cold War tended to render transnational rights talk as at best a kind of auxiliary story to what was seen as the more significant Soviet-American geopolitical rivalry. This marginalization in the scholarly literature about human rights was also reinforced by a popular sense of American exceptionalism, which has seen the United States as a kind of exemplary instantiation of the protection and enforcement of human rights at home, and as always reticent, and for many who believe in American exceptionalism, implicitly justifiably reticent, to allow any kind of international norms to intrude into the sovereign space of the American nation. Now, one way of reading these global rights cases in the late 1940s, focusing on the immediate outcome of the cases, could in fact reinforce these prevailing perceptions. Notwithstanding the expansive claims and the ways in which they pushed against more rigid notions of national sovereignty, the cases themselves never brought a clear resolution to the appropriate balance between global norms and domestic policy. There is no single US Supreme Court decision in this period that granted full legitimacy to the arguments about the controlling power of UN human rights norms. Moreover, these cases unleashed a storm of controversy, becoming a central symbol for American policymakers who wanted to severely curtail US engagement in an emerging global human rights order. And as we'll see, these efforts were in part successful, at least in the immediate moment, and forced a disavowal of global rights norms in American domestic space by the Eisenhower administration in the mid-1950s. So, all of this could be read as confirmation that kind of traditionally minded notions of American sovereignty ultimately trumping more elastic visions of human rights and sovereignty, again, that located those individual rights somehow outside of the bounds of the nation state. In these senses, the global rights case might be thought of as something of an anomaly. Again, rare exceptions that ultimately prove the exceptionalist rule of the impermeability of the American state to transnational forces. My approach in thinking about these cases has a somewhat different analytical aim in mind. It's one focused much more on processes than outcomes, and processes that let us explore how the cases reveal what seems to me the contested and contingent nature of American engagement by both political elites and local actors in an emergent post-1945 global human rights imagination. In thinking with you about these cases this evening, I want to focus on three issues. First, I want to talk a little bit about the nature of the rights claims themselves that are made in these cases, but even more importantly than that, to talk about the conditions that made those claims possible and plausible in an American context too often thought to be bounded by a kind of human rights exceptionalism. Second, I want to talk a little bit about the impact of these cases on this emerging official US hostility to global norm-making in the human rights sphere. And finally, I want to talk a little bit about the ways in which a focus on process rather than immediate outcome and a kind of longer historical perspective can help point us to the lingering potency of the power and place of transnational rights claims in global and American cultural politics after 1950. Now, as I suggested earlier, this talk is drawn from a book that I'm now completing, a book that examines the American state, but also examines American non-state actors and thinking about their engagement in the construction of some kind of global human rights order. Today, global human rights talk is everywhere. But really, this wasn't so for much of the 20th century. So the central question in some ways that drives the larger project that I'm working on is why human rights became believable for so many American state and non-state actors and actors in other states as well after 1945. And it seems to me that in trying to figure that out, there are two decades that are most important. The 1940s is one, and the 1970s is the other. As a historian, I don't have any kind of a priori assumptions about what human rights are or what human rights should be. My project really aims to recover how and why, in what I see as these two crucial moments, the 1940s and the 1970s, the historical actors with whom I'm most concerned began to employ what for them was a novel vocabulary of human rights. So tonight I'm talking to you really about the 1940s. If people want to ask some questions about the 1970s later on, I'd be happy to go there, but thinking about this first moment of the 40s today. And to do that, let's go to a sense of what the conditions of possibility were in the 1940s. As some of these global human rights cases are making their way through federal and state appellate courts in the late 1940s, there are a number of state and non-state actors who support the cases as they are moving along, also looking to the authority of global human rights norms to combat domestic discrimination at home. In fact, the first mention at the national level in the United States of thinking about how the UN Charter, how UN Charter ideas about human rights might combat domestic discrimination emerges in an NAACP conference on racial covenants in July of 1945. This is just a month after deliberations over the UN Charter in San Francisco had been completed. This was part of more far-ranging conversations about legal strategies for attacking these kinds of racial covenants. And so participants were discussing the relevance of the UN Charter claims, both for making legal arguments, so for trying to convince judges that these needed to be overturned, but also because they thought these kinds of arguments would work with public opinion in the moment as well. So there's a sense, as people are talking about this, that there is a kind of emergent public opinion in the United States that's increasingly attuned to thinking about these norms that are emerging through the Charter and how they might have a kind of applicability domestically. The potentialities of the Charter for some sort of realization of domestic civil rights surface other places as well. And most notably, they surface in deliberations of President Truman's Committee on Civil Rights. Its celebrated report to secure these rights put forward a number of arguments about how to get to civil rights in the United States, but for my purposes, put forward what they termed a strong argument that US ratification of the UN Charter and its human rights provisions in fact gave Congress treaty power to protect domestic civil rights at home. There are a variety of what we would now think of as NGOs, but at that point, more sort of civil society advocacy groups. The NAACP is involved, the American Jewish Congress is involved, the National Lawyers Guild is involved, The ACLU is involved in these cases. The Japanese American Citizens League is involved in these cases. The American Association for the United Nations. I could go on and on. But there are a number, again, of these larger groups who are engaged in this as well. They share the view of Truman's Commission on Civil Rights, the notion that something happened in terms of treaty law with the Charter and human rights that is applicable in an American context. And so when petitioners in these cases came to these groups and asked if they might file briefs on their behalf as well, many of them did, again, making similar kinds of UN claims. It's not just groups in civil society who are doing this. The American state itself is making some of these arguments in these cases too. They're not only making these arguments, they're making arguments rooted in domestic practice, they're making arguments rooted in constitutional law, but it's telling that the brief that's prepared by Truman's Attorney General, Tom Clark, in Shelley v. Kramer, which is a restrictive covenants case, as these cases sort of come up through the system, they tend to get collapsed into one single case, and so these cases collapsed into something called Shelley v. Kramer. The government's brief, drawing specific attention to American support of international human rights agreements, to argue that racially restrictive covenants were inconsistent with the public policy of the United States. The brief, in fact, highlights the preamble of the UN Charter, its discussion of human rights. It highlights Articles 55 and 56 of the UN Charter, which dealt more specifically with human rights provisions, reminding readers of the Charter's approval as a treaty by the United States Senate in 1945. So state and non-state actors alike in the immediate post-war period seeing this as perhaps a believable way of thinking about domestic rights questions. So there are really two questions here. One is, how did the petitioners, their lawyers, a host of non-state actors, and at times even some agents of the American state, come to be willing to look outside the nation to global rights norms as a potentially powerful tool to combat domestic racial discrimination? And a kind of related question is, why did they believe that American judges might be receptive to such transnational legal claims? After all, if you're involved in a court, ultimately it's convincing a judge that the argument that you're making is right. You're putting forward a number of arguments and hoping that some of those will stick. There was a sense, and one of the things I try to get at is, why was there a sense that these kinds of arguments might be ones that judges would hear favorably? It seems to me that there's a domestic and there's a transnational dimension to answering those two questions. These cases that emerge in the late 1940s emerge against what I would see as an extremely fluid political moment in the United States, both at home and in thinking about the world outside of the United States. Scholars who work on African American history, who work on Mexican Americans, who work on Native Americans, and who work on Asian Americans have devoted significant attention over the last decade or so to the struggle for civil rights in the wartime and the immediate post-war period. So civil rights issues, civil rights litigation are clearly ascendant on the domestic political stage, but the kinds of claims that were advanced in these cases and recognized were far more complex and contingent than some previous scholarship has acknowledged. There has been kind of an American scholarly fixation on Brown v. Board. This is the 1954 school desegregation case that came before the Supreme Court, and also on the Equal Protection Clause of the 14th Amendment of the United States Constitution as the kind of foundational genealogies for post-war anti-discrimination doctrine. And the focus there has obscured what was a varied scope of civil rights practice in the 1940s. In that sense, invoking the UN Charter on Human Rights was part of a broader and diverse, if understudied, repertoire of post-war rights claims that were advanced after 1945. These included calls for economic and social rights, among them affordable health care, as well as more familiar demands for political and civil rights. So there's something that's happening out there domestically, even disconnected from the transnational, that is more varied, more diverse, more fluid than we have thought. As the civil rights movement is accelerating at home, however, there are parallel developments in the international sphere that produce really an unprecedented set of efforts in the late 1940s to somehow codify what human rights norms mean. The United Nations Charter is one in 1945, but the adoption of the UN Declaration of Human Rights in 1948 is often pointed to as the kind of uber document of this moment. But in fact, both the UN Charter's human rights provisions and the UN Declaration of Human Rights, were simply the most dramatic examples of what was a far wider phenomena, to articulate some kind of global vocabulary for the protection of individual and political civil rights and the promotion of collective economic and social well-being. So for instance, in Latin America, there are wartime discussions about human rights that culminate in the adoption in 1948 of the American Declaration of the Rights and Duties of Man. At the same time, these conversations are going on in Latin America. Western European states are beginning to draft their own rights lexicon. They produced the European Convention on Human Rights in 1950. In Geneva, member societies of the International Committee of the Red Cross begin discussions in 1946 to craft protections for the rights of non-combatants in times of war. As this is going on, the International Military Tribunal at Nuremberg is developing the concepts of crimes against humanity and crimes against the peace that would become cornerstones for the theory and practice of universal justice in international human rights law as time went on. Finally, discussions at the United Nations, again, all of this happening in the late 1940s, center on a convention to outlaw genocide, a global freedom of information covenant, concerns about protective rights of asylum for refugees, discussions about a convention on statelessness, and the beginnings of drafting legally binding guarantees of the political, economic, and social rights that are outlined in the Universal Declaration. So, domestically, civil rights on the ascent in more complex ways, perhaps, than we've thought of in the past, and in a parallel set of developments, again, the emergence of this kind of global vocabulary or lexicon of human rights norms. Now, the United States does not stand apart from these transnational developments, from the norm-making that's going on in the late 1940s. The American state and a number of non-state actors are deeply involved in efforts to construct this new global human rights order from the outset, really. So American leadership, on one hand, was crucial in the 1940s. On the other hand, American participation and American thinking about this was also deeply shaped by domestic ideas, domestic practices, and particularly domestic sensibilities about race. There was a vocal minority of Americans who were implacably opposed to having any engagement in international order at all. So they were there. They were always there. They continue to be there even today. But along with them, there were a number of policymakers, particularly people in Congress, whose concerns about protecting a kind of Jim Crow racial order at home meant that anything that was going on abroad about human rights was instantly suspicious to them. If you were supporting a Universal Declaration of Human Rights, if you were supporting legally binding covenants that would bring those aspirational ideas into being, what impact would that have on a segregated South? What impact would that have on African Americans? And so, for white policymakers in the South who didn't want to see Jim Crow come to an end, there's a danger about how deep America can go. And because those Southerners controlled important committees in Congress, they controlled important relationships with the executive branch, their voices, for better or for worse, mattered in all of this. So the Americans are engaged in the construction of all this, but there's always the lingering potency of race and the kind of political valences that race had in the United States that put something of a brake on this. That said, there is this kind of moment of possibility in the 1940s for rethinking not just the way in which human rights are talked about, but perhaps rethinking the boundaries of national sovereignty as well. Now, I want to say that it's not just Americans who are thinking along these lines at this point, so I don't want to re-exceptionalize the United States in this regard. And I want to talk just very briefly about a parallel effort that was emerging in the United Nations by the Indian government that seems to me quite similar, actually, to these global rights cases in the United States. The Indian delegation at the United Nations in 1946 sought to win the support of the General Assembly for a resolution that criticized the South African government. It criticized the South African government's passage that same year of what was called the Asiatic Land Tenure and Indian Representation Act, which basically was setting up a sort of discriminatory set of treatments for South Africa's large Indian population. Now, the ironies of South Africa being on the docket as sort of the first major human rights case in front of the General Assembly in 1946 were certainly there, and they were deepened by the fact that the premier of South Africa, Jan Smuts, had in fact helped to draft the human rights language that was in the UN Charter. Now, given that South Africa is and had been a kind of apartheid state and was about to become a very serious apartheid state in the 1940s, Smuts must have thought that somehow the charter could never apply to him, but nonetheless engaged in the language, but his practice is quite different. He insists that the General Assembly can't have anything to do with this sort of question, that it's a domestic question, one for South Africa to sort out, but not one to engage the General Assembly in. Does this sound like a familiar argument about states worrying about human rights at the UN? Anyway, the South Africans insisting that the domestic jurisdiction clause of the UN Charter, this is Article 2.7, prevented any discussion of the matter. However, there continued to be sustained debate in the General Assembly, and ultimately India's argument that the General Assembly could in fact hear and rule on cases like this one, cases that violated Charter human rights language, won the day by a 2/3 majority of the General Assembly. Quote, "The treatment of Indians in South Africa," the Assembly ruled, "shall be in conformity with international obligations under the agreements concluded between the two governments and the relevant provisions of the Charter." So it was in this liminal moment when articulations of rights and sovereignty were in play at the intersection of the domestic and the transnational that the petitioners in the American global rights cases and the judges that heard them acted to harness what they saw as the potentialities of an international human rights guarantee and perhaps also more relaxed conceptions of national sovereignty to combat domestic discrimination in the United States. This sensibility would, for instance, allow a California court in one of the Japanese land right cases, this is say Fuji versus California, to argue in a 1950 opinion, quote, "Discrimination against a people of one race is contrary to both the letter and to the spirit of the United Nations Charter, which as a treaty is paramount to every law of every state in conflict with it." The California court in, say, Fuji was perhaps the most muscular assertion of the domestic reach of global human rights norms. But nonetheless, a substantial number of state and federal courts, and in one case, several Supreme Court justices, proved receptive to these sorts of claims. And their responses, in a sense, reveal the horizons of possibility in the late 1940s for articulating looser conceptions of state sovereignty in cases of domestic racial discrimination. And the range in court decisions is from a willingness to grant moral, if not legal, authority to transnational rights guarantees to the full embrace, as the say Fuji opinion went, to the power of the UN Charter's human rights provisions for the American state and for federal law. So it seems to me that these cases can help us think not just about what was going on in the United Nations in terms of setting up a whole set of international human rights norms, but they let us think about the ways in which they played out in important and quite profound ways in 1940s America. They help us, I think, thicken the real and imagined potentialities of a kind of emergent human rights order in the American context. But at the same time, these cases are also helpful to better understand the forces that prompted the American state in the 1950s to begin to retreat away from this kind of engagement in global human rights. So I want to sort of shift to the kind of second set of issues that I wanted to talk to you about tonight. Within days of the announcement of the Say Fuji decision, again, this decision that UN charter norms trumped federal law, it was denounced. It was denounced on the floor of the Senate. It was denounced on the floor of the House. There were op-ed pieces that were moving around in various newspapers around the country, again, arguing that this was a kind of travesty for the United States. And in fact, Say Fuji and some of these other global rights cases emerge as a really powerful vehicle through which proponents of something called the Bricker Amendment. In just a minute, I'll get to exactly how the Bricker Amendment is related to all this. But the Bricker Amendment, which sought to severely limit US participation in a kind of larger global rights order. There were hearings, very public hearings, that were held about the Bricker Amendment in 1952 and 1953, and they're a really rich site for beginning to capture opposition in the United States to what was seen as transnational intrusions on what were properly domestic questions about law and civil rights. Laced throughout the discussions and debates, Senator Bricker, along with his allies in the Republican Party, in the American Bar Association, and a number of conservative organizations, make frequent reference to Say Fuji, they make reference to Oyama, they make reference to Sipes vs. McGee, and many of the other cases, as emblematic of a transnational assault on, quote, existing laws, which are in our Bill of Rights and our Constitution, thereby forcing unacceptable theories and practices upon the citizens of the United States of America. They were, Bricker and his allies said, quote, a blueprint for tyranny. Now, the Bricker Amendment was ultimately, if narrowly, defeated. But the vociferous debate that it produced did bring the Eisenhower administration's very public disavowal of the Genocide Convention, of the UN Covenant on Human Rights, and other instruments of international human rights protection in 1953. In fact, Secretary of Dulles goes before the Bricker Committee and tells the Senate, quote, we do not ourselves look upon a treaty as a means by which we now would select as the proper and most effective way to spread throughout the world the goals of human liberty. The Eisenhower administration, he continued, and this in a direct reference to these global rights cases of the late 1940s, quote, welcomed a reversal of the trend toward trying to use the treaty-making power to effect internal social change. Now, I would say that rather than revealing the presence of some kind of enduring and implacable American hyper-sovereignty, that the opposition to the assertion of global human rights norms in an American context, again, as it emerged in the very public hearings in the United States Senate on the Bricker Amendment, is perhaps best viewed as an example of what Giorgio Agamben has called the performance of sovereignty. In their often shrill insistence on the naturalness of an American state somehow set apart from global processes that were surrounding it, the Bricker Amendment hearings, to me, betray the essential brittleness of this kind of imagined construction of a hard and fixed sovereignty. Now, there is, of course, some irony in the fact that the very cases that sought to enmesh the United States in an emergent global human rights order provided the impetus that pushed the United States further away. Bricker and his allies were successful in forcing what would become an almost 2 decades-long official disinterest in global human rights politics. And it wasn't just at the level of the American state. Many of the non-state American actors, especially those civil liberties and civil rights groups, who had been so closely involved in these global rights cases in the 1940s, they also retreat from these efforts to link human rights and civil rights. They do this largely because talk about human rights begins to brand them as potential communists. And in 1950s McCarthyite America, that sort of branding was the worst possible thing that could happen to you if you were trying to make a case for civil rights. So they evacuate human rights and return to the notion of civil rights thought of more in a domestic concept. Now, the waning of what admittedly were always liminal and fragile dimensions of this human rights moment of the 1940s, it doesn't seem to me means that the decade of the 1940s in thinking about human rights should be approached as a kind of death from birth. And in fact, that's how some scholars have talked about this particular moment. The top-down elite sphere of human rights norms making at the United Nations, particularly the drafting of the Universal Declaration of Human Rights, which has been the focus of most human rights history in the 1940s, it seems to me can obscure this understudied but perhaps even more prevalent constellation of everyday on-the-ground efforts to harness again the fluidities of the immediate post-war moment for the making of a new global and local human rights politics. Still, though, exploring these denser textures of the human rights moment of the 1940s should not blind us to its own internal contradictions and limits. If a kind of universalizing vocabulary of human rights norms could be powerfully employed to try to address these local instances of domestic discrimination, they could also operate to erase the particularities of the rights claims that were made in their name. In the early post-war period, for instance, the Nazi genocide against Jews in Europe was drained of its specificities, and a particular Jewish fate came to be represented as universal human suffering. Not only was this so at the Nuremberg trials, where the murder of Jews was subsumed under the label of, quote, crimes against humanity, the universalizing impulse resonated even more broadly at the level of popular culture in the United States. For instance, Anne Frank's diary, the reception and presentation of Anne Frank's diary in the 1950s. It becomes an international bestseller in the 1950s. It's a popular stage play and film in the 1950s. It's probably most Americans' most direct encounter with the notion of a Holocaust, although in fact the notion of the word Holocaust isn't the way in which people are talking in the 1950s. But nonetheless, it downplays the centrality of the Jewish dimension of the Anne Frank story and the kind of richness of Anne's own personality. And in their place, the lives of the Franks get rendered as a kind of uplifting symbol of humanity. Again, this sort of universalizing tendency. And Anne herself becoming a somewhat cliched figure who possessed a sort of never-ending optimism and hope for mankind. Again, the way in which the diary actually works, the self-presentation of the diary are quite different, but it comes back to this sort of universalizing impulse that is a part of this 1940s human rights moment. This more general tendency toward a kind of absolutism for defining what universal human rights are in the 1940s, and I would say also a reluctance sometimes to consider particularities, political, economic, social particularities in local spaces, is something that was not just about the human rights moment of the 1940s, but has persisted until the present day. One final American legal case illuminates, I think, well, the fluid complexities of the 1940s global rights moment as it operated in the United States, and also the diffuse legacies of the 1940s as well. This is a case called Rice versus Sioux City Memorial Cemetery. It emerges in 1953 in the wake of the death of Sergeant John Rice in the Korean War, and it comes to court just on the eve of the Bricker-inspired Eisenhower administration's rejection of a variety of human rights treaties. So in this case, Rice's widow, a woman by the name of Evelyn, had entered into a contract with a cemetery in Sioux City, Iowa, a cemetery that would bury her husband. Evelyn Rice was white. John Rice was Native American. He was a member of the Winnebago tribe. At the graveside services, literally as they're putting his body into the ground, several cemetery officials noted what they took to be a number of Native American mourners who were in the funeral party, and suddenly began to think to themselves, maybe Sergeant Rice himself is Native American. So after the burial, they come to visit Rice's widow, Evelyn, and they say, you know, this is what we saw, this is what we think might be the case with your husband. And she tells them, well, that is quite right. My husband is Native American. The cemetery officials tell her that they have a Caucasian-only burial policy, and so order that her husband's remains get dug up, right? So we have the Korean War veteran whose remains are being now dug up in the Caucasian-only cemetery in Sioux City. Now, this drew, in fact, immediate and national attention, and it prompted President Truman to intervene, who arranged for Sergeant Rice to be buried at Arlington National Cemetery. But John Rice's widow, Evelyn, was a kind of feisty woman, and that really wasn't good enough for Evelyn Rice. And she decided to take the Sioux City Cemetery people to court. She takes them to court on UN Charter grounds. Takes them to the Iowa Supreme Court, and the Iowa Supreme Court rules against her, and so she decides she's going to take the case to the Supreme Court. And in the brief that they submit to the Supreme Court, her lawyers deal at some length on charter-inspired claims. And I just want to read you a bit of this so you can get a sense of the kind of flavor of how people are talking about this in the moment of the 40s and early 50s. They argue the purposes of the United Nations Charter cannot be fulfilled if the racially restricted covenant in question can be used as a defense to the conduct of the cemetery. If the cemetery is to prevail, it is because the petitioner married an American Indian rather than a member of the Caucasian race. It logically must follow that while the cemetery could not avoid the payment of damages if it had acted in a similar fashion against one whose husband was a member of the Caucasian race, yet nonetheless it can avoid the payment of damages to this petitioner because of an interracial marriage. The Iowa court is tolerating this discrimination and at least indirectly is punishing this petitioner because she married a non-Caucasian. In doing so, the Iowa court had, quote, violated the basic and very fundamental concepts of equality, not only announced but also pledged by the United Nations Charter and all of the member nations of which the United States is one. So again, coming back to the United Nations Charter to stake a claim for what was wrong in this case. The persisting use of Charter human rights provisions in the Rice case echoes other American global rights cases of the period, and it seems to me its appearance after the Bricker Amendment controversy suggests that the Eisenhower administration's official hostility to international human rights guarantees was not completely acknowledged in the realm of domestic civil society. But if the indignities of Sergeant Rice's death and burial were shared between Evelyn and the broader Native American community, the individualist renderings of human rights in her legal challenge weren't necessarily shared. Native American activists in the 1950s increasingly saw efforts by the American state to challenge tribal sovereignty, self-government, and cultural autonomy as their most pressing challenge. They were less interested in the individual rights claims that underlay the UN Charter and much of the 1940s human rights moment. What resonated more deeply for them were struggles for collective self-determination in the decolonizing global South, and increasingly by other indigenous peoples elsewhere in the world. So, even in the United States, depending on who was thinking about these kinds of questions, they too might see this moment of the 1940s in different sort of ways. Operating at the intersection of the transnational and the local, the quotidian human rights interventions of the 1940s American global rights cases, it seemed to me, are always filled with friction. Whether it's the impact of the UN Charter on an African-American couple about to lose their home, whether it's the bombastic Senator Bricker from Ohio, or it's the widow of a Native American soldier who served and died in the Korean War. It's in uncovering those frictions that I would argue that we can begin to make real the contours and the boundaries of a mid-20th century American and global human rights imagination. That's what I have for you.